What up? What up? It's your boy Mo Cheese, aka Grits, broadcasting live from the Country Roads Diner. Special edition of the show coming at you at 3 o'clock in the afternoon, as we usually would come at you at 10 o'clock in the morning. But I had some special guests that I wanted to make sure that I got on with me today. Today's show, we're going to talk about the judicial system. We're going to talk about Georgia, and what better person to bring along for this ride if we're going to talk about the judicial system and we're going to talk about the state of Georgia, other than my brother Charles A. Brown, who is in the building with us already. Charles, how you doing, sir?
I'm doing okay, big bro. I'm doing okay for the day.
And we also have a special guest that is also on the line with us that'll be joining us via phone. And Charles, I'll let you have the pleasure of making that introduction.
As for comrade Mr. Paul Nalley, that's what you asking?
Yes, sir.
Yes, Mr. Nalley is a good comrade, and I tell you no lie, Mr. Mo. Uh, this interview is gonna be very educational and much needed. And with that said, I'll let Mr. Nalley take it from there.
So we have Paul Nalley joining us via phone as well. Mr. Nalley, how you doing today?
Doing pretty good, young man, considering these 77 years.
Hey, I'm just trying to get there as well.
Amen.
Hey,
of course, I'll let you in on a little secret. You know, it doesn't really matter how old your body gets. In your mind, you're always going to be a 19-year-old hellraiser.
I've been noticing that, but I've been trying to tell myself that, hey, that's probably not going to work for the long term. We're gonna have to I'm gonna have to at some point turn 35, although I'm 43.
That's right. We got to fight that urge every day.
Yes, sir. So we have a couple of different things that we wanted to get you on the line to discuss with us today. Okay. And I don't know exactly where Charles wants to start, so I'll let Charles kind of sort of guide the way on this. Are we starting with the JQC complaint?
To be upfront and most needed to be done is Mr. Nalley is the person that filed this document into the court, Superior Court, and I would like for him to share the information to the people, Mo, if you don't mind.
Oh, not a problem at all. Not a problem at all. Mr. Nalley, the floor is yours.
Okay, thank you. I had an opportunity to go to the polls early to vote, and I went in, processed in, went to the machine, made my selections on the screen, and bear with me just a second. I'll call you back. Anyway, when I was through making my selections, I hit the print key, and of course it spit out this piece of paper with my selections on it. But much to my surprise, in addition to the office selections and the candidates that I selected, there was not one barcode up at the top of it. There were two barcodes. Now, I had already had an opportunity to read Georgia Law 21-2-300 and a couple of other code sections. And all of the code sections mandated that the ballot printed out would be readable and verifiable. Well, here's the problem. I couldn't read that QR code. My cell phone couldn't read the QR code. So what I did is I just laid my ballot down on the table in front of me, stood up, took out my cell phone. I made two pictures of it. Then I put the phone back in my pocket and picked up my ballot, pulled out the green card that you use to activate the system. And I walked over to the machine at the door to put the green card in the box where it goes, which I did. I then turned to go out the door, and the poll worker who was standing there at the machine said, "Oh, wait a minute, sir. You gotta put your ballot in the machine." And I just looked him right in the eye, and I asked him, I said, "Can you cite me a provision of our Constitution or any statute that says I have to vote this piece of paper, or that I have to cast this piece of paper as a ballot?" "Well, no, but you've got to put it in." And about that time, another individual came up and interrupted me and wanted me to go have a seat so they could go get the election officials to, I'm assuming, find out what they needed to do. So I went over and had a seat, and it wasn't but just a minute. The door across the room opened up, and here come the election manager. Well, bless his heart, he knew who I was. Them other two didn't. He just kind of looked at me and shook his head, and he walked over to me and he said, "Paul," said, "have you got your ballot?" And I said, "Sure do." And I opened up my file folder. I said, "Right there it is." And I'm headed over to court with it as evidence. So he just kind of had a little bit of a frown, and he turned to one of the other poll workers and told him, said, "Go mark his vote as having not voted." And she said, "Okay." And she turned and left, and he said, "Go ahead, Paul, get out of here." So I left. Well, I was aware of a code section about elections and judicial procedures, which was covered under 21-2-412. Now, the way that language is written, you would think that if there is any election activity going on, that there would be a judge in his office to handle election complaints, or at least a judge assigned that duty, even if he had other cases that he needed to hear. Well, when I get over to the courthouse, I find out from the clerk that no judge has been appointed under 412, and no judge is assigned to be in his office at 7 o'clock Tuesday morning. See, I was there on Friday afternoon on the 4th. So there wasn't going to be a judge there on election day either. Now, this is the Cherokee Judicial Circuit. This is Bartow County and Gordon County. So I just kept my evidence with me and left. And the more I thought about it, the more angry, you could say, I got at the fact that the judges in this circuit didn't give a rat's fanny about the rights of the people having a forum to which they could complain about the legality of an election ballot. Now, there's a good reason for that, and that's because under Georgia Code, it is a misdemeanor. It's a crime if you vote or cast an illegal ballot. Well, my ballot's illegal. I got 2 QR codes up there on the top of it, and neither one of them's required or permitted under state law. So then there's another statute which says that if you are caught outside of a polling place with a ballots, then you have committed a felony. So, needless to say, when I walked out that door, I was looking at being arrested, but it didn't happen. And I still have my ballot right here on the desk beside me. Now, I probably, this term, this election cycle, I have been deprived of my right to cast a legal ballot in the general election. And not only that, I was denied my right of redress, seeking redress through the courts of the Cherokee Judicial Circuit. So like I said, the more I thought about it, the iller I got. So I just sat down and I had another issue to bring to the Judicial Qualifications Commission anyway. So I just sat down and wrote a JQC complaint against all of the judges because they're all responsible individually and collectively for seeing that the process, the legal process, is complied with. So I wrote that up. And then the additional complaint that I had was that two of the judges in this circuit, back in the beginning of 2022, we had the time frame set down for candidates for office to file their notice of candidacy. And these two judges did. Now, when they file that notice of candidacy, they also file an oath saying that they are not the holders of any public monies, public funds. Well, it just so happened I had evidence that both of them had not paid some state fines that had been levied against them for well over a year. So I wrote out that my complaint on that against these two specific judges, and I attached it to an email, fired it off, and that later that afternoon I got a response from a little lady down at JQC that she was in receipt of my complaint and that she was filing it immediately. So needless to say, since the date of that JQC complaint, I've not heard a word.
Nothing.
Don't expect it, because they like to keep judges' malfeasance close to the vest. They don't want the public knowing about just how corrupt some judges can be. But anyway, I expect probably within the next 30, 40 days to get a email from the JQC saying, oh, we're sorry, but we couldn't find sufficient evidence, so your case is dismissed. But that's okay. There are other remedies available in the law.
I love the way that you're approaching the situation, and you're very calm and you're very rational, but you're very deliberate in how you plan to move forward. I see.
Well, deliberation is a key to accomplishing objectives, and of course, education doesn't hurt a bit either, because if you read the criminal statutes don't apply to old fogies like me, and it don't apply just to John Doe out on the street. Some of these criminal acts that can be committed are committed by public officials. And of course, the last thing a public official wants is to wake up one morning and find out that, hey, there's a warrant application headed your way, and you're going to have to go tell a judge why you shouldn't be criminally prosecuted with a warrant against you. So, that's what they've got to look forward to if the JQC doesn't jihad on this matter.
Wow. So what is you said that obviously you haven't heard anything back. What is the next step? What's the next step to move forward? And outside of, obviously we can give you a voice, we can give you the voice, and we can put this information out anytime for you. And I will make sure that I continue to share this information as I actually have your JQC complaint I have it pulled up on the screen. So I've gone through it. I've scrolled through it. Everybody can sit back. You can look at it. You can pause the screen. You can read everything that Mr. Nalley has just stated. And you can see the complaint that was filed. I'm wondering, what's the next step and how do we help you in moving forward?
Well, now, I almost started to say there's not anything y'all could do, but that would be a lie.
There's always something we could do.
Yes, there is. And the one biggest thing that can be done is to open up the grand jury doors. Now, this is what I'm about to talk about the grand jury. The problem with the grand jury is not an African American problem. It's not a white American problem. It's all our problem. And when I say that, what I'm talking about is when a member of our community receives a summons from the clerk to show up in court Monday morning at 9 o'clock to be potentially selected for jury service. When they get to the courthouse, they ain't got a clue what's going to happen. And what's even worse is if their name is called and they get up and move to another seating area where the grand jury members are being seated, then once they go elect their foreman, come back into the courtroom and raise their hand and take the oath of a grand juror, 99.999% of them don't even listen to that oath of office. And even if they do, it's probably no more than 3 minutes before they forgot what it said. But unfortunately, the oath of a grand juror is an oath taken which makes an individual citizen the most powerful public servant anywhere on the face of this earth. I mean, literally anywhere. Because as a grand juror, not only do you go over the evidence that the district attorney can bring you on violations of criminal codes committed by some of our ne'er-do-well neighbors, but you have the absolute right to make criminal inquiries into all elected public officials. You can stick your collective nose, in any government official's business you want to. I don't care if it's the governor of the state of Georgia, the Secretary of State, the Chief Justice of the Georgia Supreme Court, or if it's the local dog catcher. Everybody in between. And everybody, by the way, who is not a public official are all subject to a grand jury inquiry. They can stick their nose in anybody's business. And the beautiful part of it is, when they are in the proper performance of their duties as defined in their oath of office, they are untouchable. Nobody touches a grand jury. Now, especially when they're in term. When a grand jury is in term, nobody is going to mess with a grand jury, not even the district attorney. And district attorneys, so there's a lot of district attorneys in this state that they'll look you dead in the eye, and they'll swear up and down, we're the gatekeepers of the grand jury, and you ain't going to get there till you tell me what you want to do. Well, that ain't what you do. The proper response for any citizen is to look that district attorney in the eye, or if it's a judge that tells you that, you just look them in the eye and say, it ain't none of your business. And here's the case law. And then you cite Henry Butler from 1895, which plainly says that any communication between a citizen and a grand jury is a confidential and preferential matter, and nobody has any right to know what your business is with a grand jury. Now, that's I'm talking there about the citizen's prerogative of going to a grand jury. Now, the next question is, well, what if you're sitting on the grand jury? What is your duty? Well, your duty is very simple. You listen to the complainant. That's it. Once you have heard what they wanted to tell you, then you got to ask yourself one question and one question only. And that is, does what this gentleman or lady is complaining to us about, does it touch upon our present service? And if the answer is yes, now the grand jury must go into diligent inquiry and come out with a true presentment. Now, one of the things you need to understand is when a grand jury takes on its own investigation, that is to say, the district attorney ain't bringing you an indictment for you to sign or to listen to evidence from some law enforcement officer, then you are engaged in a criminal inquiry just like the local sheriff's investigators would be doing. Whatever, the things they do, they go out and get evidence, collect evidence, they go out and interview people. That's exactly what you do as a grand juror. And to get that information, you have subpoena power. Nobody can deny coming. I mean, yeah, they can fight coming to a grand jury, but they're not gonna win. And here's another neat trick about grand juries. If a grand jury calls in somebody as a witness, they don't want to testify because they're afraid that if they start talking, they're liable to let something slip that would incriminate them as being a party to the crime that's under investigation. That ain't a problem.
Ms. Nalley, can I interrupt you and ask a question? Since you're talking about grand jury, it raised the question because what I see, and Charles, you can maybe speak to this. Usually, when people are indicted when they are indicted on charges, and it goes before a grand jury. In my own experience, in the state of Georgia, what happens is the person that is being indicted on those charges. Now, I know you're speaking from the opposite end, but still, just speaking into it, the person that's being indicted is supposed to be notified, correct?
No.
No?
No, sir. A grand jury investigation is strictly an ex parte communication. That means that the object of the investigation does not have to be notified. Well, I take that back. Unless he is a law enforcement officer.
Oh, okay.
Now wait a minute. Let's back up here. There's something you got to understand about this. State law does not command a grand jury to inform a law enforcement officer that he's under investigation. And the reason there is no state law requiring that is because the state legislature in our Constitution, Article 1, Section 1, Paragraph 11, last sentence on subparagraph A says, the legislature cannot make any law concerning a grand jury other than their selection and their compensation. So the way the legislature got around having to tell the grand jury, oh, you got to let the cop know that he's under investigation for abuse of force. The way they get around it is they tell the district attorney, you will provide notice. And you will tell them when to show up to testify before the grand jury if they want to testify. So that's how the legislature gets around telling grand juries what to do and when to do. You see, our grand jury in our Constitution, and by the way, Georgia is the only state that still has a grand jury, a common law grand jury firmly ensconced in the black letter law of our Constitution. What they did is our representatives and all, when they were getting together to work on our Constitution, they reached over into the common law and they picked up the grand jury fully clothed with all of its powers and duties and responsibilities and set it right square down into our Article 1 of our Constitution. Now, that makes the grand jury an Article 1 court of inquiry. Why is it a court? Because every member sitting there is a judge. Our Constitution specifically states that trial jurors and grand jurors do not determine just the facts in a case. They judge the law. Now, you got to stop and think for a little bit. How awesome a power is that?
Right.
A grand jury cannot make law. They cannot make law, but they can sure as heck strike down a law. Not only that, but they have the authority with that power to be judges of the law to inform the legislature, look, you got a problem with this statute, and we're going to strike it down, or you're going to amend it. Which way you want to go with that? I mean, that's powerful, man. That's powerful stuff.
That's almost. I mean, it's almost above the law, is what it sounds like.
Getting close, getting real close.
Very, very close.
And I will tell you this too about the jurisdiction of a grand jury. Some folks might want to know, and that is that every issue that comes before or that appears before that grand jury, doesn't matter how it gets there, it has to start in their county. Now, if they hear of something over in another county and they receive some evidence that tells them, hey, golly, that sounds pretty bad, somebody ought to look into that. All they got to do is send a grand jury letter to the neighboring county's grand jury foreman and tell them, this is something we've heard, y'all might want to look into it. Now, here comes the rub, though. The question is, where's the jurisdictional line for a grand jury beyond which it cannot go? Well, normally, if it starts in your county, the limit is your county line. But what if you find out that a crime has been committed in Washington, D.C., and it had an illegal effect? It actually committed an act of theft against John Doe, who lives over here about 3 miles from me, here in the county. What's the limits of the grand jury's jurisdiction then? Well, in a case like that, in any case where a grand jury has to investigate and follow the evidence, that county line evaporates. The state line evaporates. The borders of the United States evaporates. If you want to see the limit, if you want to cast your eyes upon the limit of a grand jury's jurisdiction, you need to walk out that door and look up.
Okay. So why I guess I would ask you, why does it seem like so many grand jury trials And I guess maybe I just don't know enough. Maybe I don't pay enough attention, and maybe you can educate me some. Maybe you can educate some of the listeners. It seems like when something goes to a grand jury, it seems like it's somewhat rushed through. It seems like there's a quick decision made, and maybe that's what you were speaking to at the beginning of the interview when you said, the people go in, they get a set of instructions, and within an hour and a half or so, they don't remember anything that they were instructed to do. They're not, thoroughly educated.
And thoroughly educated. Right there, young man, you just put your finger on the problem. And I refer to it in this matter, in this way. The educational system of this state and this nation has performed an absolutely marvelous and spectacular job of educating this people to the maximum level of their acceptable ignorance.
Except that you know what? Please let me give you this, sir. We have not used it, but let me give you this.
Lay it on me.
This round of applause. Let me give you this round of applause. Like you said, they have educated the people to
the maximum level.
To the maximum level
of their acceptable ignorance.
Acceptable ignorance. I love it. And you would think, okay, so you start out school, and obviously we're not talking about pure elementary, but once you start learning about history, the first thing that you learn is the 4 branches. You learn about the judicial system, but it doesn't seem like we take enough time in those history classes. Maybe one of those history classes actually needs to be some kind of basic law.
Absolutely.
Much like we do an economics class. Yeah, we do an economics class. Why don't we have a basic law class that teaches people these are the basic rules for courtrooms if you are ever called, which we all know that we're going to be in a pool of people to be on you're going to be on a jury pool. Why aren't those things taught in school?
Now, the answer to that is very simple. Politics is interfering with the rule of law. They do not want you to leave high school. Hold on. Let me just ask you a question. Let me ask a question to you and all of your listening audience.
Okay.
I want all of your listening audience to sound out right there where they're sitting and tell me how many corporations they are sitting members of the board of directors of in this nation, in this state or in this nation. How many? So, if you don't mind, I'll pick on you since you're the one who's got the audio going.
And not a problem.
I'll just ask you to tell me.
Yeah.
Now, you may be incorporated for the purposes of this podcast.
And I am. Yes, sir.
Then, okay, that makes you the owner and the CEO and the president of the board of directors.
Correct.
Okay. But how many more corporations do you hold a seat as a board of directors member? How many other corporations?
How many other corporations do I hold a seat on?
Yes.
Well, personally, and maybe I'm going to answer this question wrong, but I have my business incorporated as far as the podcast. I have a business incorporated as far as a lawn service. And I mean, technically I would be part of the board for X Squad Radio, but I would just say 2.
Well, now I got to ask you a question.
Okay.
Why have you sat there on this podcast and announced to the world that you're a liar?
That I'm a liar? Okay. All right. Tell me about it.
The reason is because the day you turned 18 years of age, that is the age of majority. that is also the age when you walk up to this humongous table and you reach down and pull out a chair and you take a seat at the board of directors of two of the largest corporations. And by the way, I ain't just talking to you now, I'm talking to all your listeners out there. You are sitting at the age of 18, you take a seat at the board of directors of two of the largest corporations in the world, the United States of America and the state of Georgia. How in the Sam Hill does that happen?
And I'm assuming at the age of 18, you become legal to vote. And at the age of 18, you become legal to go into the military.
Yeah. Well, yeah. But that is defined in our statutes as your age of majority. That is the age at which you can contract without anybody else being liable for your successes or your debts. At the age of 18, you take a seat. You have been seated for the last 20-something years. Well, maybe 20 years. You have had a seat at the board of directors of two of the largest corporations in the world. Now, let me ask you this question. Have you or any of your listeners conducted yourselves as conscientious and dedicated board of directors members?
To those two entities?
Yeah.
Well, I feel like this is a trick question. I would say
you're rather perceptive, young man.
I would say if you have exercised your right to vote, then yes.
Well, okay, fine. You've done half your job. When are you going to do the other half?
Which would be following up on who you voted for, I'm assuming?
Keeping an eye on them. And if you catch them doing something wrong, then you go to your grand jury, because your grand jury is how you manage that corporation between the elections. You go to the polls every 2 years, at least. You're voting for somebody every 2 years. What do you do in the meantime? Well, if you catch them screwing up, you go to the grand jury and let the grand jury know. That's their job.
Makes total sense. Makes total sense. Again, I guess when you put it that way, it makes total sense.
You know, this ain't hard to understand. It really ain't. But anyway, I guess I've bumped my gums here on that a little bit too long. Is there another question that somebody may have? Or
yes, I have a question, Mr. Nalley.
Yes, sir. Go right ahead.
Yeah, we all listening to you live and Instagram on my platform and others. And what we are asking is, once we identify the informant, not the informant, but the foreman, once we identify who that person is, male or female, probably be someone that live up the street from you. But once we identify who they are, what would be the proper way to introduce the wrongdoings to them, the right way?
Well, that's real simple to answer. First off, you can send a letter to the grand jury foreman or to the whole, or you can send it to the whole grand jury, and you will put down the clerk of court's address on the envelope, but you address it to foreman or maybe foreman and grand jury of whatever county you happen to be in, and address it to in care of the clerk of the court's office. Then the clerk has a duty to, when the grand jury convenes, to take that and put it in the hands of the foreman or any grand juror. But that's not the only way. You may run into this foreman, or you may run into a neighbor that you know is not the foreman, but a member of the grand jury. You can let that individual know of your complaint, and that individual has a duty to inform the minute they all come back together. he has a duty to inform his colleagues, his fellow jurists, that there's a problem and lay it out for them. And when he does that, then, if they've got any other questions, they can send you a subpoena and you can show up and give your testimony. Or in Georgia, it doesn't have to be testimony of a fact. You can take a rumor, nothing more than a rumor that you heard. Maybe you was down in the corner shooting pool and you overheard a conversation about some kind of a crime or some malfeasance that was going on, and you thought you needed to get that information to the grand jury, so you go see one of the grand jurors or you go to the foreman and just tell them what you heard. And once they hear it, if it's something that's within their jurisdiction, which touches upon their present service, then they go stick their nose into that business and find out what the Sam Hill's going on. And the way they can do that is simply go call the sheriff in, tell the sheriff, look, we've heard this rumor. Send your detectives out and have them investigate this and bring us a report. They can tell the sheriff what to do. They can tell the district attorney what to do. They can tell a superior court judge what he better do. And if they don't like it, if the judge just ignores them, or the DA or the sheriff, they can take them people out of office right then.
Now, I just want to let everybody know we are on the line right now with Mr. Paul Nalley. He actually, and if you were watching the show earlier, if you're coming back to watch the show, he has actually filed a junction, JQC, which is Junctional Qualifications Commissions, against, or a complaint basically against the it's Cartersville, correct?
Yes.
Okay. Against
four judges here in the Cherokee Judicial Circuit in Bartow County.
Okay. And the thing that sparked this in all actuality was a complaint arriving at the poll, or a complaint with the processing at the poll, where the QR codes were supposed to be readable, and the QR code was not readable. And I'll just read it to you. Observing that there to be two QR codes legally printed on the face of the ballot, complaint stood up, used his cell, or I do apologize. Complainant stood up, used his cell phone to make two pictures of his ballot, picked up his ballot, retrieved the green card, proceeded to the scanning device, deposited the green card, and proceeded to leave the polling place with his ballot, being adverse to violating Titles 21's. And what was Title 21?
That's the election code.
Okay. So when you went over, let's go. I want to just quick rewind. When you went over to the courts, as you said, they knew exactly who you were. When you went over to the courts, did you get any kickback?
No, because the clerk's office didn't have a clue that judges were even supposed to be available on the following Tuesday. They didn't know anything about it. They were, they were just like I was 6 months, a year ago. They were just dumber.
And it clearly states, which again, you can go back and read. You can look at the full complaint. The complainant arrived at the courthouse, proceeded to the clerk's office to inquire which judge was sitting as the Section 412 hearing officer, and was advised that no judge had been assigned that duty to the knowledge of the clerk, but that all judges had their caseloads of trials for that day. Complainant had taken the time to convert his complaint into written format for the convenience of the judge. Being denied his provocative, or am I saying that right? Or Am I?
Prerogative.
I thought, okay, I did say it right. Prerogative to avail himself of Section 412 hearing. Complainant was deprived of his constitutional access to the court for a legal, non-discretionary, self-enforcing 412 hearing and his due process, and was violated in his First Amendment right by violating the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States.
Now listen, you and everybody else needs to take that statement right there, and you need to chisel it into your heart and your mind.
And that's the no state shall make or enforce
any law
which shall abridge the privileges or immunities of citizens of the United States. That's pretty much every law, isn't it?
Yeah.
that's every law.
In the exercise of your civil rights, you cannot be criminally prosecuted, nor can you be civilly prosecuted. That is your right, constitutional right of immunity. Now, can you bear with me for just a minute? I've got some gentlemen here.
Absolutely.
I'll be right back.
As a matter of fact, this is what I'll do so the people can actually hear you. We'll take about a 3.5 minute break. So I'm gonna take a 3.5 minute break. There'll be music playing on this side, so we'll be right back after this 3.5 minute break. You guys bear with me. I have Charles A. Brown on the line with me of We the People, and I also have, and this is a very enlightening conversation. We'll have Mr. Paul Nalley on the line with us. And not necessarily voter suppression, but I guess it kind of sort of steers down those lines. So we're going to take a quick break. We will be right back. If you are watching the show, tell a friend and tell a friend to come on in. This is Country Roads. We thank you for joining the show. We will be right back.
Thank you. Thank you all too much. Y'all so kind. But if y'all don't mind, the next selection we like to do for y'all is, Country Roads. Check me out. She told me not to be so cold, said a true OG, you let y'all motherfuckers know about some real pimpin'. And not just sitting on your lows, cause all your rims spinning. Don't make it down her country road, you got to get 'em up, get 'em up, get 'em up now. Hit 'em up, hit 'em up, hit 'em up, yeah. Get 'em up, get 'em up, get 'em up now. Hit 'em up, hit 'em up, hit 'em up, yeah. Get 'em up, get 'em up, get 'em up now. Hit 'em up, hit 'em up, hit 'em up, yeah. Get your ass up, get your ass up. Eeny, meeny, miny, mo, off I go and it's a heater. Rotten something swerving, conjunctions conjured by the tweeter. This one here's a lesson, look like I'm gon' play the teacher. Instant classic, I knew it when it blew the back speaker. Hater, ain't it, James it, grain it, it show no pains, man. That you're going far away and the light just ain't gon' bring me. Say I got this gift for gabbing, the game just ain't gon' change me. Say the writing's on the wall and that shit is written plainly. Got a fetish for divas, popping tags and blowing reefer. Hanging with my people, you gotta know it don't get no sweeter. How they supposed to keep up? One left nut talking about they bust. Take 2 steps back, stop fucking with us, cause I'd be dead wrong if I roughed you up. But
she told me not to be so cold, said a true OG, let y'all motherfuckers know about some real pimpin'. And not just sitting on your lows, cause all your rims spinning. Don't make it down her country road, you got to get 'em up, get 'em up, get 'em up now. Hit 'em up, hit 'em up, hit 'em up, yeah. Get 'em up, get 'em up, get 'em up now. Hit 'em up, hit 'em up, hit 'em up, yeah. Get 'em up, get 'em up, get 'em up now. Hit 'em up, hit 'em up, hit 'em up, yeah. Get your ass up, get your ass up. Fascinated with the story of Muskogee one. How many different ways we supposed to come? 3, 5, 4, from just might throw some. Take away your breath and expose your lungs. You can tell the way I stroll alone. The kid got the golden tongue, make 'em weak in the knees, her toes are numb. Baby lick shot with a mama's gun. Well, Papa got a brand new bag of tricks and mad clips, so ain't for the sky. Grip tight, squeeze and fire. Black in the barrel, why did I pimp my pen? I pimp my pen like pimpin'. Kid don't want it, then have reach for the roof in the Holiday Inn. Let me feel good in my moccasin. Mama say, Mama sa, Mama kusa. Ain't one spit it like like moi. Slim picking, sipping, pimp, polish up your repertoire. Always bon voyage and au revoir to your big ass crib and your nice ass car. Got 4 TVs with card and all, but a thick ass bra said no. Oh,
She told me not to be so cold. Said a true OG, you let y'all motherfuckers know about some real pimpin'. And not just sitting on your lows, cause all your rims spinning. Don't make it down her country road, you got to get 'em up, get 'em up, get 'em up, nah. Hit 'em up, hit 'em up, hit 'em up, yeah. Get 'em up, hit 'em up, hit 'em up, nah. Hit 'em up, hit 'em up, hit 'em up, yeah. Get 'em up, hit 'em up, hit 'em up, hit 'em up. Get your ass up, get your ass up.
she told me, what she say,
Don't be so cold.
said a true OG.
Now what she say?
Let y'all motherfuckers know, let y'all motherfuckers know you got to
Get 'em up, get 'em up, hit 'em up, hit 'em up, get 'em up, hit 'em up, hit 'em up, hit 'em up, get 'em up, hit 'em up, hit 'em up, hit 'em up, get 'em up, hit 'em up, get 'em up.
get your ass up, get your ass up.
All right. Appreciate y'all for joining us during that quick break. Needed to take a break. I don't know if Mr. Neely's back with us just yet. Mr. Neely, you back with us?
Hello.
Okay.
Can you hear me?
Yes, sir. Yes, sir.
Okay.
All right. So, Charles, where'd you want to go next, Charles? Charles, I think you might. Yeah. Okay. There you go.
Yes, the document that you have displayed here, Mr. Mo, is that, and that is the petition, correct?
This one is I got the petition up right now in front of me. I can put this
Right.
on. Let me see if I can put this on big screen for.
Okay. The petition that you see here is the petition that we have flown around and requesting so that it can be um, understood of why Mr. Nalley placed that JQC complaint in here in Georgia against those judges there in Carterville, Georgia. And I want the people to understand the message that we are delivering through this complaint. And we call it a blessing to be able to allow the people to see the malfeasance, the bias, and racism that's stemming from these counties here in Georgia. In the petition, I definitely want it to be understood that Mr. Nelly point out of how this petition, as well as the power of the grand jury here in your county. And Mr. Nelly pointed out something along with this petition, that if you see something, do something that would make a change
Amen.
and a difference in your county.
Amen.
And that statement alone is enough to tell every grand jury that gets an opportunity to participate to make a difference, a change in your community. Be inside of that courtroom. Do not throw that summons in the mail. I got to be to work. You tell your boss man not today. And you go inside there and participate and be a part of a change that you crying out every day in these neighborhoods, marching and screaming. And then realize you the one, you the people, you the individual that can make a difference. And the things that we saying today, and I say again, this petition that Mohab displayed, please understand the language. Please understand the language of the JQC complaint, the cries and tears that defendants, individuals, laid behind the walls and cells daily trying to get their wrongful conviction overturned. And Mr. Nelly stated again, I'm going to say it proudly, because I just learned something today, how powerful and unlimited are the grand jury, the ones that get summons in the mail. So, Mr. Nelly, I wasn't trying to take much of your time, but I did want to point out the significance of what you taught me today, of the power of the grand jury. Now, I have seen the grand jury go into a county jail and demand that sheriff, why there's no paint on that wall. I never understood
Yeah.
what that means. because we were so young at the time being kidnapped by these slave catchers we call police officers and being
If I may,
charged. Yes.
if I may interrupt briefly, I'm expecting a call sometime around 4:00 that I will have to take, and I'll have to drop off. But before that gets here, I would simply like for you to help everybody understand that if they take their Constitution and they read that, and then they take the statutes and they read those, then take a pencil and paper and sit down and draw a graph of the power structure in each county. And what you're going to find is that the most powerful entity up on top, if you want to know who that individual is, go look in a mirror and you will be looking him or her right in the face. Now, the second most powerful is the grand jury. The third is the sheriff. And everybody from the Superior Court judges right on down to the dog catcher are under him. That is your hierarchical structure of power in your county. It is you, it is your voice, and your neighbors who are sworn as grand jurors. The two of you are responsible for managing your county. And I'll yield.
Mr. Nalley, I thank you for taking some time out with us today. If you don't mind, we're going to reach back out to you, try to get you back on, maybe get you on via video. We could put a face to the voice. But thank you for being a voice for the community.
Well, you're more than welcome. I'm hopeful that I was some help to you today. And just so everybody knows, I've been in jail 3 times for this, so I think I paid my dues.
Most definitely. Most definitely. If you willing to fight it enough to go behind those bars, which I've been behind them as well. If you're willing to fight it that hard, it's something that you care about.
Let me make this observation too, and that is this: when you're wrongfully put in jail, you got to keep one thing in mind. You're in damn good company, okay? By that, I mean, you got to remember, John the Baptist went to jail. Jesus, who became the Christ, went to jail. The Maid of Orleans went to jail. And Dr. King and Mahatma Gandhi, all those went to jail. You're in good company.
I agree.
You got to remember that.
I totally agree.
And I'll yield.
Well, thank you for your time, Mr. Nalley.
Definitely thank you, Mr. Nalley.
Thank y'all for having me and putting up with my running my mouth.
Oh, anytime. Like I said, we'll be reaching back out to you. I definitely want to get you back on. I want to get your perspectives. I wanted to ask you a question, and I didn't want to make it a black and white conversation, but can I just ask, what is your ethnicity?
My son went and got his DNA checked, and it came back all Western European.
Okay. And I was just wondering, and I guess I was wondering to make a point, somewhat, and for those that know, they know what point I was trying to make. I guess everybody always feel like there's a barrier and there's black and there's white on opposite sides of that barrier, and I just wanted to make the point that that's not always the case.
Well, look, let me explain something. I guess maybe I had a misbegotten upbringing because my father was part-time farmer and part-time mail carrier out in the country, and our neighbors that wasn't next door, it was probably about 200 or 300 yards away. But our next door neighbor was a black sharecropper, and me and my brother and his kids were always, if we weren't in the fields chopping the cotton or picking cotton, And I hate to admit it even to today, but God, them boys could outpick me hands down. I never could catch up to the kind of cotton picking they did. But anyway, we were always playing horseshoes, or we were running off to the woods building bridges out of fallen down pine trees. We were doing something. But the point is, you know, we were just a bunch of American kids out having fun. That's the way I grew up. So anyway, I'll hush.
I got you. Well, thank you again. Again, we're gonna reach back out to you, try to get you back on the show. But we thank you for the time that you took with us today.
You're more than welcome, young man. God bless all of you.
All right, you as well. All right, brother Charles. Thank you again for bringing him, sir.
Right, it's more than a pleasure.
Hey, he was real. He was so real about it too, bro. He's just like, let me throw it out there for you.
Wow, and going to jail with this information, going to jail, providing this information to the people would motivate me not to go to jail, but to continue to share the information, deliver it to the people so they can get a proper understanding.
Right.
That we not out here by ourselves. So I had to bring them on, Mo. And there are plenty more individuals that we would like to bring on to the show as well, man. So if you would like to have me 10, 15 more minutes, I'm available. But if not, you know, it's all over and all in. But I do want.
Oh, I got you. What you got? What you want to get into?
Well, I wanted to go a little bit more in depth of the grand jury information of the process, the summons and things, and the power of them. Because he really got me a flame burning in my hand right now. So I really want to touch up on that, and that would be all.
Okay, you got it. You got the floor, bro.
Right. So when Mr. Nalley was indicating about the foreman, on every grand jury there's a foreman, and what caught my attention, I do want to collaborate a little bit more with you, Mo, when he said that if the grand juror, the people, see something, say something, and they do something, attaching themselves to the grand jury foreman with the complaint that they seen and they want action done. So I said to myself, not to be funny, but it is an interest with a conflict of the poverty and domestic and the mental anguish on a daily basis as we as Black people go through our childhoods and growing up. And you be called for a grand jury to participate and say something, to do something. But here it is, they want to dismiss you from the proceeding because your cousin or your auntie is the person is being indicted. And I had wanted to ask Mr. Nalley, but I asked you, in that situation, what would be the appropriate things to do?
Okay. If what I'm hearing, if the question I'm hearing is correct, so you're saying if a person is being indicted, there's grand jury put together, and a person's family member is on the grand jury. Is that what I'm hearing?
Right.
I to be honest with you, I think it's a conflict of interest. I don't think a person's family member, I mean, however objective that they may be, if we're talking about the court system and we're talking about legal proceedings and we're talking about, I'm not the way that things happen. If we're talking about the way that things should happen, if it's a person's family member sitting on, I say it's a conflict. I'm gonna say it's a conflict of interest for two reasons. That person could be heavily in favor of their family member, or that person could hate the shit out of their family member. You know what I'm saying? So the reason there's conflict of interest, like it could be one of those two. Now you could easily come back and say, well, a normal person in the public could do that. It could be a normal person on the public that actually know this person, that sit up there and say that they don't know them. They may know about them. So let's say you on my grand, you on my grand jury, right?
Right, right.
But we not saying that we know each other, and we don't have any community ties to each other, but we know each other, but we not saying it because I think you're going to be in favor of me. That could happen. Or you could sit up there and say that you don't know me, and I could be like, hey, nah, I know buddy. Me and him actually had a run-in. You know what I'm saying? Like, I know we had a run-in, like, and I know him. So, but I think when it comes to a person that's actually part of somebody's family, bro, I think there's a direct conflict of interest that could be pointed at very easily on that one.
Right. And the reason why I asked that question, not to confuse anyone, but to say if the summons does come in the mail, if you don't want to participate, and which I hope you do, but the power of it. And Mr. Nelly indicated that if, like I say, if you see something, say something, and you do something. And my question was, to him, which I did have asked a while back, why did they incarcerate you?
Hmm.
And he stated it's because of the information that we giving out to the people. And I said
Hey,
to myself,
again, which goes
were
back to
they
the
locked
question I
anyone
had,
else up?
which goes back to the question that I had to ask him. And I had to ask him before we got off, which I already knew the answer, but I just had to ask him, what is your ethnicity? Because I want people to realize, like, no, there's some people out there that's not brown or black that's actually fighting for us as well. You know what I'm saying? I don't want to just think that this is a brown and black fight, because until the fight carries over to the I don't want to say nothing ridiculous. Until the fight carries over to the Europeans, the colonizers, etc., until everybody gives a damn about it, then the true progress won't happen.
Right.
But he's so on it, bro. The fact that he immediately left from the voting poll, like, yeah, let me just go on over here and file this paperwork. Like, it sounds like it's just something that he does on a regular anyway. But it sounds like it's something that he does in the case of right. It's not something that he just does to be belligerent or something that, it is like, I know the law. So anytime that I feel like the law has been impeded, I feel like as a citizen, I have the right to challenge it. And I feel like that's exactly what he's doing.
Right. And you're absolutely right, big bro. And also to add with that petition that you had up is the petition um requesting for a evidentiary hearing of the allegations that have been brought to the table. And so this court hearing that on November the 30th, now that court date has, will determine how they will proceed with this information, because their petition language, it speak clearly. If the judge deny, then he denied the Secretary of State as well as the Attorney General as well as Kemp. So that means there's no process for a complaint like you and I if we have an issue with that Q code. And again, inside of that language, it tell you Mr. Nelly are looking at a felony charge according to the law. And that's is where if Mr. Nelly get a felony charge, so will the Secretary of State as well as Kim as well as the Attorney General. So this is one of these type of situations, November the 30th, where we have to stand with them. That court case would be in Statesboro, Georgia. And they call a 412 hearing.
Mm-hmm.
And inside of that 412 hearing, I never heard of it, but I have gained enough understanding to know that we must support that court date. So if anyone have anyone in Statesboro, Georgia, please do come by and support this 412 hearing, November the 30th.
All right, now tell me a little bit about this petition. I don't know if you can see it. I got it up on the screen for you. Is this the petition that we're talking about? And I think this may be a example of how it should be filed. Petitioners direct this petition to the sound discretion of the circuit judge of Baker County, Oregon, for his impeding and charging of a grand jury for the consideration of this petition. This is how you would file it, correct?
Well, remember that's in Oregon.
Right. This one is a case, like this is using a case that has already been done as an example of why it can be done, correct?
Okay, look at the capture on the left-hand side. Those are the individuals that's in violation. At the very top of the petition.
So Kim Thatcher and Senator Dillis Lyncham and Dr. Henry Ely III in their individual capacities. And just so if y'all can't see it on the screen, I'll read it real quick or I'll try to go through it. As far as the allegations, petitioners and associates or petitioners and others associated with them have uncovered evidence of fraud and presumption of negligent homicide, along with a preponderance of evidence indicating probable victims within the state of Oregon arising from the COVID pandemic. On this date, this group provided an overview of its data to each of the several United States attorneys around the nation with a request that the data and our names as witnesses be provided to their respective federal grand juries. Not one replied to our request, and none submitted our data to the grand jury. Now, why? Let me just ask you, because I know some people probably are looking, they're going to ask, okay, well, why is this case in Oregon pertinent in regards to what we're talking about?
And the last line, you read it back again because it stated that no one responded.
Correct. It said none, not one replied to our request, and none submitted our data to the grand jury.
Right. Now, go back to the caption, and those are the ones that did that. And they have an oath of office to uphold to not violate citizen constitutional rights, period. And by not responding, that's a violation in itself. The question is why they not responding. Continue to read.
So, hold on, let me go back. I apologize. All right. So it also says on this date, the group filed in the United States District Court at Portland, Oregon, a request for the federal judge to impanel a grand jury to hear the petition of these complaints. Petitioners Exhibit 2. Due to the naming of several federal officials as respondents to our request, we were opposed in seeing the exercise of our First Amendment rights of petition, peaceable assembly, responsible speech, and hearing by the federal grand jury by the United States Department of Justice. On November the 11th, 2022, District Judge Hernandez filed this order in that case dismissing petitioners, which is Petitioner Exhibit 3. The said dismissal had the legal effect of denying petitioners rights through the misuse of otherwise proper rules of federal civil procedures. Such misuse violates and irreparably injures not just these petitioners, but all citizens of the state of Oregon and of this nation as well. So that's the part of particular and poignant interest to these honorable grand jurors is revealing excerpt from Judge Hernandez Judge Hernandez's order of the dismissal starting on page 5 of Exhibit 3. No injury in fact. The Supreme Court has repeatedly held that the private citizens lack a judiciary cognizable interest in the prosecution of non-prosecution of another. Okay, so these are all cases. Let me just go down. Plaintiffs may not act in their place. What? Whereas such mandated in the Constitution or in any act of Congress. How does such even I'm tripping off that statement. I'm sorry. Plaintiffs may not act in their place. Like what does that even mean? How does such even comport with right to petition for a redress of grievance? No injury in fact when Supreme Court has held in precedent that the deprivation of First Amendment freedoms for even minimum periods of time unquestionably constitute irreparable injury. So basically what it's saying is that the fact that they were deprived their First Amendment, when they were deprived their First Amendment, there was injury occurred judicially. Right? I'm just making sure I'm making sure I'm following, making sure the people follow.
Correct.
All right, we're gonna go down a little bit. There are other misstatements of federal law and rules of procedures which petitioners and their counselors shall point out to the honorable jurors. However, it will be the sound discretion of the said jurors to determine if such references are in fact accidental misstatements of law made in ignorance, indifference to ignorance, or intentionally made for an illegal, deceptive, and malicious and fraudulent purpose. Now that was you know what, Charles? This is why I asked him the question in regards to when a person is arraigned and a grand jury is assembled, why is that person not petitioned? Because at that point, I feel like, okay, that's when the lies start. Basically what they just said. So that's, and for cases of what we're talking about, that's when the injury actually happens. Especially if the person that's being arraigned is not aware of a grand jury trial and is not able to sit in to see what evidence has actually been presented or what has been said, because that information could be wrong for a couple of different reasons. It could be wrong on purpose. It could just be a flat out lie. Or as it said, it could be a incident of ignorance. You know what I'm saying? Indifference to ignorance, or intentionally made for illegal, deceptive, and malicious and fraudulent purposes, meaning that now the grand jury has heard fraudulent information, malicious information, has made a decision in the grand jury to say, yes, we're going to indict this person that was never notified. And they never had an opportunity to speak up for themselves. You know where I'm coming from on this one.
And that's where this conversation is leading it to, and good trouble like Mr. John Lewis, and that's what we barking down this road on. Mm-hmm. And you're absolutely correct, family. Now, to help soothe that injury, we are asking for the grand jury master list. Now, the person that holds that list is the clerk or the court. Now, when you get arraigned, if you don't holler, scream, or tell your public defender something, then you definitely indicted and arraigned, and now they send you down for trial. But before you get arraigned, there's a couple things that you can do. You can take that true bill indictment and give it back and challenge it. The true bill indictment. And everything that you said does give leverage to challenging the true bill indictment. Meaning you ain't have no witness, you wasn't put on proper notice. You can go down the list of things. Or maybe just walk back to the form and say, I want to press charge.
Right.
Right.
And you know what? So and again, to take it back to my situation, when they served that true bill warrant and I got out and I bonded myself out and I went to the DA's office and asked them, where did y'all send the paperwork letting me know that I was even being arraigned on charges, and the address was wrong. At that point, I incurred injury. The address that y'all served these papers to was not the address. That wasn't even the address that I lived at, bro.
and that's what they call disposing of the case or the body, because they finna issue a warrant and come kidnap you and place you in a concentration camp, which they call a prison system.
Which you
And
said it. How do you serve paper saying that I'm being arraigned to address X, which nobody even knows what the hell this address is, but you come pick me up at address A, which is my address that's on my driver's license that you have. So you came and picked me up from an address. Why didn't you serve me papers to that same address?
wow, and those are the tactics that they use. Those are the tactics that they use, and if you don't have enough money to afford an attorney that can provide you that service or overturning your conviction, then
Not even that though, Charles. You want to know what, man? I would say this: even if you have an attorney that you've paid for, you got to have this knowledge, and getting the knowledge 2-3 years later isn't necessarily helping me. But I'd be damned if I don't put it out there for somebody else. You know what I'm saying? But I'm just saying, your attorney has to be competent enough that when this is a major issue, one of your major issues, the attorney has to be competent enough and steadfast enough to pursue that part of the issue. Like I told him in the beginning, again, I'm talking about my own case. It was like, I never received notice. Oh, well, this happens all the time. No, it shouldn't. It shouldn't.
happen.
This should never happen. It should never happen that a summons from a court was sent to a wrong address. So basically what you telling me is Clayton County makes it their business to send court summons to the wrong damn addresses so that they can say, oh, well, you didn't show up to court and now we gonna put out a warrant for your damn arrest. But you never received notice.
Right. And that's called kidnapping the body and places on the concentration camp where they work the rest of their life and don't be asking for no parole.
I'm gonna tell you
That's why they do that.
Bro, I'm gonna tell you what I had a public pretender tell me. I had a public pretender tell me that I should check the county courts on a periodical basis to ensure that I don't have a warrant out for my arrest. And I wanted to say to her, and ladies, excuse my language, I am not calling you. I want to say, bitch, are you for real? What am I checking? Why am I checking the county courts randomly? If I'm a law-abiding citizen, why in the hell would I check the county courts to see if I have a warrant out for my arrest periodically? You just randomly, like on 3 times of the year, you just got a calendar set to say, you know what, let me go in and see if I got any warrants. But you ain't been arrested.
And that sound like most public pretenders here in Georgia. And it's sad to say they don't care. They don't care. They don't lose no sleep. And that's the end of that.
Pretty much.
And big bro, I wanna take you to one other document. Saturday request.
Okay, hold on 1 second. Let me get over to it. 'Cause I already got it pulled up.
Yeah, Saturday request. And I definitely want the listener to understand that piece of document as well. And it's gonna rock your world as well as the other documents have done as well.
All right, we got it.
Okay. Now, there are 3 statutes in that document that control contract law or contract agreement. And if you don't mind, can you please read those 3 statutes, if you don't mind, on the front page here?
Are we talking about OCGA 13-10?
Yeah, it's 3 of them though.
When writings or contracts are intended to have effect in this state, they must be executed in conformity to the laws of this state. With the rules executed in place, we now turn our attention to the rule of construction in the case of Old Hickory Prods versus Hickory Specialties. The constitution of the contract is to be governed by the law of the place of its making, unless it shall appear that the writing or contract is intended to have effect principally within the state of Georgia. In Georgia's law of contracts, there is the cardinal rule of strict construction when the intent of the parties is clear and converts no rule of law, and sufficient words are used to understand that the intent, the contract must strictly construed or must be strictly construed. However, that is not the only time that the strict construction requirement is mandated. The other is in dealing with constitutional rights, where any enactment and derivation of the right must be strictly construed. Otherwise, it may be held unconstitutional, such in the case within Georgia's election code and citizens' rights of franchise. When reading the Georgia's Dominion contract, there are two Georgia statutes which must be kept in mind. OCGA 1-3-6, after they take effect, the laws of this state are obligatory upon all the inhabitants thereof. Ignorance of the law excuses no one. And OCGA 15-19-17, clients shall not be relieved from their liability for damages and penalties imposed by law on the ground that they acted under the advice of their counsel, but are entitled to redress from their counsel for unskilled advice.
Now, at that junction, at that area, at that spot, those three laws go in order as you read. But the third one go toward Georgia Public Pretenders or Defense Counsel and the person that hired them. I want the people to understand these documents, Big Bro, how important and how powerful they are. We didn't get to this point of going to jail, battered and bruised, been biased, and retaliated against. We are demanding the people to attend this court hearing. I just got a couple emails earlier indicating put pressure on the court date because you'll never get a chance like this again. And they said that same thing about Stacey Abrams. And I say again, these documents are so important. Now, the last law in Georgia that you just stated that they can be held accountable, meaning your counsel, your public defender, and the person that hired them. So when we speak about the grand jury, these are three different documents in two different states. And there's other people pushing these documents as well because they understand the truth and nature of it and how it can make a difference here by participating in the grand jury proceeding. Holding your public defender and the person that hired them accountable. And we'll get in more depth behind that, big bro. And if you can read that last part of that behind that, bro, and that'll be it. And I'll take it from there, big bro.
All right, it says the poignant interest to the contract is 1-3, or I'm sorry, 1-3-6. In the conceptualization and implementation of contract language, it is imperative to know exactly what the state's laws say. And in the case of this contract, the legal beagles did not do too bad of a job until they got down to Exhibit B, subpart 3.1. It appears that the Socrates process just went out the window at that point. You see, the legislator amended the election statutes and the governor signed it into law on April 2nd, 2019. Now, I don't know how long contract negotiations have been going on. But by the time of the signing, August 12, 2019, 5 months had passed. That was more than enough time for some attorney to have realized that a 2D barcode was not authorized to be on the face of an official ballot, yet nobody caught it. Or maybe it was intentional and unlawful provision, or intentionally an unlawful provision was allowed to remain. Here's a result of the intent or oversight. So let me ask you this. So basically what this is saying, that 2D barcode was not authorized for Georgia ballots at the time that this was signed?
As see, now this document is so very important. Yes, you are correct, and a lot of folks went along with it. But as you continue to read, you'll see why it wasn't permitted and how unlawful, unconstitutional it is as we speak right now.
All right, let me read. It says, upon first making a selection on the BMD and the ballot being printed, an elector observing his ballot being illegal as containing on its face markings which are not readable, not verifiable, and not authorized by an active legislator is faced with the problem of not casting or voting his ballot. For to do so would place him in violation of voting an illegal piece of paper, which is a misdemeanor under 21-2-57 or 579. He may then refuse to cast or vote an illegal ballot, simply retaining it and leaving the polling place, in which case being in possession of a ballot outside of the polling place subjects him to a felony prosecution under 21-2-57-4.
Right.
While at the same time being denied his right to vote. Alternatively, he cannot tear his ballot and dispose of it in a trash receptacle, since destroying the ballot is also a crime. So basically, casting an illegal ballot or casting a ballot which was not readable, not verifiable, and not authorized by legislation is illegal, which is basically the ballot that they provided. So they provided an illegal ballot, but disposing of the ballot is illegal. Taking the ballot outside of the polling place as evidence is illegal. Well, what the hell is legal? So it sounds like the whole voting procedure that went down, everything about it was illegal. You couldn't even verify outside of taking a picture, I guess. You couldn't tear the ballot up. You couldn't put it in a receptacle. But the ballot shouldn't have existed.
Wow. That's all I said. Wow. And as you continue to read, these are the scare tactics that they use to keep the grand jury from understanding what their power is.
So let's real quick. Let's hit the two remedies. There are two possible remedies. First, a challenge to the illegal provision found in Exhibit B, subpart 3.1. If it is found to be and ruled void by court of competent jurisdiction, then all elections from August 12, 2019 would also be held void, which would mean that the need for another election for all offices held during that time. The reason for that would be that any officer holder prior to August 12, 2019 would be in office de facto, and any office holder who won an election after that date would have yielded his office to a previous holder and new election held. Such court ruling would also void Georgia's electoral college results. The second remedy possible would be to challenge the whole contract as void for an illegal purpose. If proven and voided, the results of the office holders would be the same. Exempting Dominion would have to go through the whole contract application process again. What it sounds like is there's a remedy to the problem, which the remedy to the problem is there should have been a new election. But that would have been too much like right. It wouldn't have been, well, I'm sure it would have caused some problems, but causing problems to do the right thing is the right thing to do, right?
Correct.
I'm just saying.
Correct.
I mean, if we gonna cause problems, we gotta cause problems for the right thing. And it seems like from everything I just read, Georgia's election in general, even when it comes down just to the ballots that were there, was illegal.
And that's what the document displaying with evidence. And this what's on the legal table for them to rule on, make a righteous judgment, and or do the right thing. And that's why these three pieces of document is so important. And each three documents saying the same thing about in two different states. So the JQC is Judicial Qualification Committee. That committee is only established through the legislators and Supreme Court judges that place them there. Kemp just have to make sure they being supervised. That's his job as the governor. But who put them there and making sure that the laws and policy on that board be upheld, then that complaint went to them. So anybody that got an issue with a judge, you get a JQC complaint and you file it along with information to the grand jury. And so at this point, where we at now, that 412 hearing, that means courtroom support, unity in the community, and we stand and support Mr. Nalley and his legal team that got us to where we at now, to understand that we can make a difference if we go to the courthouse and stand with him and his legal team on November the 30th in Statesboro, Georgia. And the reason why I say we can make a difference in that by participating and going out and meeting his legal team. And get educated how you can go back to your county and demand a change if you see something wrong. You dig? So we see a lot of males and females inside of the prison system, and we just now learned today how important the grand jury is, and they should not be in there anyway.
Right. Not as fast as they call them the grand jury, and the grand jury's not being I don't think the grand jury is doing the job that they're supposed to do, especially as Mr. Nalley just told us. They can subpoena information. They can verify the information. They can subpoena witnesses. I guarantee you that shit ain't happening on these trials. I guarantee you it ain't happening on regular man trial.
What grand jury hearings?
Right.
At grand jury hearings, not even when you was arrested, and I think it took 90 days to 120 days to get you indicted.
No, sir. So with mine, they had my grand jury hearing was on my birthday. Was on January the 8th. Right, on my birthday. And they came, the true bill warrant was issued, I guess, that day. And the fugitive squad came for me on 6 days later, on the 14th, which was my brother's birthday. So it took 6 days, and I think they filed this paperwork in December of 2018. My grand jury hearing was January 8th, 2019. And like I said, I turned myself in on January the 14th when I was notified that there was a warrant out for my arrest. And I bonded out on the morning of the 15th and immediately went to the DA's office to find out, like, where was this information? Like, where did this even come from? Like, where did the information get sent to notify me that I was even being arraigned on charges? Because I had never been arrested. I had never been arrested. I had never been charged with anything.
Right. And again, at that arraignment, that is the time to say something most times. But we these three documents definitely have enough information so that we can make a difference and make a change at grand jury participation. because that's what the issue is. We not participating. And when we do get called out, you don't show up anyway. And if you don't show up, then how in the hell did Will and Ted get indicted? You at home or at work when you supposed to be inside of a courtroom participating in a grand jury proceeding
And be the
with
main
your
one.
name on his paper.
And be the main one on social media talking about free Tronquez.
Well, when you look at the grand jury, that person's name is on that paper. What I'm trying to point out is, if your name on that paper and this is a high profile case, you lying to get hurt, and you don't have no clue what going on. You just at a red light chilling with your children, man.
And
And
somebody
all of a sudden
T-bones.
you get sprayed down at the red light,
And you don't know why.
and you don't know why.
Yeah.
And that prosecution misconduct.
Mm.
That prosecution misconduct, family. And that, and as these shows go on, we are going to continue to expose the prosecution misconduct of how these district attorneys are using these citizens, these voters, Georgia voters, citizens, and using them on a fake bogus indictment, leaving their name exposed on high profile cases, and they don't have a clue, and they not in the courthouse participating in a grand jury proceeding. But if that person that you indicted and say to you, why you did that, you know you shouldn't do that, and then you can say, cuz you don't know for real.
Look, we about to get ready to go into a new year. And I'm about to change up some things. So for the people that are looking at the show, typically I do a show on Tuesdays, 10 in the morning. I'm just gonna let everybody know I'm about to go away from that for a minute. I'm still going to do the evening show on Tuesdays, more than likely, because that's what works out with the fellas. But going forward into next year, I just want to kind of sort of change things up a little bit. I do want to recommit to discussing these cases. So I want to say at least once, if not twice a month, you know what I'm saying, we get on here and we can talk about these cases. I haven't figured out what day it's going to be just yet. It may change up from Tuesday. It may still be Tuesday. But as things change, things rearrange. And, you know, we gotta get better, and we got to get better at what we're doing. So in an attempt to do so, the show's probably going to go from 3 hours to a 2 hour show. So I'll give you more compact information, number one. And it's just straight information. We're not doing breaks, none of that stuff. But like I said, I want to make a commitment with you, Charles, that at least once, if not twice a month, that we come on, we talk about some of these cases, and we put it out there exactly what's going on, because we got people like you, we got people like Brother Stone, we got people like Al Bartell, you know, Tawanda Graves, that have their feet right there on the ground, and that are doing the work in the community. We just need the people, as you would say, we the people. We need the people to join the we. You know what I'm saying?
Right.
We need the people to join the we. Hey, listen, y'all will be quick. Y'all will be quick to the crate challenge. Man, if we was on here doing the crate challenge, boy, these numbers would go crazy. But let us come on here and tell you how to keep your freedom. Let us tell you how to keep your freedom. Ain't nobody, you don't want to share that. You don't want to share that. Let us tell you about how grand juries work. Oh, you don't want to share that. You want to know when you want to share that? You want to share that when Breonna Taylor gets shot down and it's taken before the grand jury and they decide not to move forward with the case. Then you want to talk about grand juries and how grand juries work. No, man, it's a 365-day fight. 365 days fight supposed to happen. The round it's look, how many rounds is it in boxing?
12.
How many months is it in a year?
12.
Man, y'all better get y'all ass in the ring and start fighting. Stop playing. Stop playing.
Boy, you too crazy. That's about right too, fam.
You
That's
see what
about
I'm
right.
saying? It's a
I like
365
that.
day fight, man. It's 12 rounds in a championship fight. Man, you always in the championship fight. It just so happened you start a new fight every year on the 1st of January, if that's why you want to start your calendar. You know what I'm saying? Every year you start a new fight, man. Let's be champions. Champions for our community, though.
Right, 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 right. So, with that said, big bro, I commit to that once a month, 2 times a month, however you address it. I just enjoy the time and the effort of giving out to the people, man. That's what I love, and that's what I like doing. And I want to continue with you, if you don't mind.
You got it, bro. You got it, man. We gonna do that for the people. For everybody that's watching the show live, we thank y'all for watching the show live. Please share with your friends. For those that are coming back to watch the show, make sure you take time to look over the documents that we provided. Make sure that you take the time to read the documents. You can always reach out to me on countryroadsexp@gmail.com. You can reach out to Charles A. Brown on Facebook, Charles A. Brown. You can go look at We the People, Cordell, Georgia. Look at some of the work that Charles do. Go look at the street groomers. Go highlight my people on that end as well. But again, we have people that are out here in the streets, but we need more. Like I said, Charles's organization is called We the People. We need the people. You know what I'm saying? So y'all are the people. Y'all that are watching right now, y'all are the people. So the change starts with us, and the change don't really have a color. So y'all stop putting color on the change. Let's just change the situation. Charles, you got anything for him before we get up out of here?
Love, family, stay safe.
Hey, we up out of here. I will be on tonight. It's a long story. 9 p.m. Eastern Standard Time, right here, same channel. Put your kids to bed before you jump into that one, because we going stupid tonight. I'm just letting you know. We are going absolutely stupid. Thanksgiving stories. Have you ever been stood up? Matter of fact, if you haven't gotten your tickets for Columbus, Georgia, Funny First Friday is going down on this coming Friday. So make sure you get to advance purchase tickets there as well. Go back, look at the last show. You'll see all the links, how you can get your tickets. Yep, we plugging. Go back and look at the last show. Go look at the last show. Go look at the last show. Nah, but for real, thank y'all for taking some time out of your day this evening. If you're looking for sports talk, if you're looking for the crazy conversation, come back this evening. I'll have all of that stuff for you. We'll be back with It's a Long Story this evening. Thank you for tuning in to the show one more time. It's your boy Mo Cheese, a.k.a. Grits, signing out from the Country Roads Donna. We go.